Hey everybody, it's Greg Siskin. I'm here with Jesse Bless or Jay Bless this week. We have Chuck Cook is still on holiday, celebrating who celebrates their birthday for this long on there. Chuck has been like going weeks on this, milking this birthday for all it's worth. But he's still on the road. I think he's coming back soon on there. We've been just seeing his Facebook pictures and enjoying that. And Aaron is in Washington. I'm not sure if he's doing work stuff or not, but it's just Jesse and I holding down the fort today. And we are happy to answer questions, although I'm logging into this through my StreamYard account. Hopefully, and we're not seeing very many people here, so I don't know if I screwed it up, but it is being recorded. So it will end up on the YouTube channel. We have stuff we're working on, also deadlines today, so we're probably going to keep this abbreviated. Also, because I've logged on, Jesse, on my account instead of Chuck's, I don't have all the banners that we usually have on here, so we'll just have to I'll have to create them on the fly here. So why don't we first update people on visa wastage and event and all of that. So I'm just going to post visa wastage.
I can take that. I mean, we're putting together the complaint now. We're actually having experts in the field and in the community to take a look at it and make sure that we have the best possible claims to put forward regarding, a series of harms that happened last year. They didn't go by priority date, which is what they said. And then they may not have allocated enough visas per quarter, and they kept saying there was an excess of inventory, and yet there were 40,000 EB2 Indian nationals waiting. And I don't know, notwithstanding that they issued all the visas, whether in fact they issued them appropriately. And that's an issue we're going to explore. But, the point of the exercise and the litigation is to help those who are now going to be facing retrogression that looks, in my personal opinion, pretty severe, because there was disclosures last week in another case that the inventory is around 45,000, and yet there's probably 5,000 available this year, which doesn't seem terribly great for dates moving forward. So, litigation, if nothing else, will hold the agency to account for the past harm and maybe get them to quantify for us how exactly their process is working, because it doesn't look like it's working for everybody, especially not our clients.
Yeah, I will say until this case is filed, we have the ability to keep adding plaintiffs up until that point, and then we actually have potentially add some more after that. So if you are still thinking about joining on this case, it's not too late. And there's the website where you can onboard yourself for that litigation, and we encourage you to do so. Okay, Jesse, let's I guess that we can tell people a little bit more than last week on Shumalina, which is the Ukraine case. Why don't you tell us where we are in that discussion with the government?
Well, we're finally putting pen to paper on the settlement agreement, and hopefully maybe by even the end of this week, we could have an agreement in place. But, the parties agree to the essential elements, which is Ukrainians are entitled to work incident to status who came in under the appropriations bill of this past year. I think we can agree that they will have work incident to status, and that, in fact, those that had applied or paid for a card are entitled, to perhaps a refund of that fee or mischarge. Details left to be resolved are, well, how much of that charge will be returned, if any, and of course, what is the timeline for when people are going to be able to actually work in the United States? Our position is yesterday, and we just have to find out about that. But I mean, in terms of the parties having differing opinions on the merits, were Ukrainian nationals admitted into the United States or paroled in, eligible to work, incident to status? I think both parties now agree that the answer is yes, because the law says so.
Yeah. So yeah, the part that I'm worried about with the government is obviously, I guess everybody else is that that they will agree that they were wrong, and then they will try and drag out actually fixing the problem as long as they can on there. So obviously that's our, as we focus on this, our goal is to get them to do it as quickly as possible. We know they have some recent experience with something like this with the L and E spouses, where they had something similar, where they finally agreed after decades of saying no, no, no. They finally agreed the statute requires them to make those people incident to status. They ended up having to change the I-94s for those people, as well as make fixes in the E-Verify system and some other changes that they had to make. And it kind of dragged out for a while as far as when those people are finally starting to see the benefit. But the good news is that they've done it for that population already. And this is actually an easier case, I think, because the entire everything on an I-94 is already there that they need. Whereas the I-94s for the E's and the L's were, in theory, deficient because there was a population that didn't qualify for the benefit, and you couldn't necessarily tell from the I-94 itself whether the person qualified for the E or the L spouse qualified for that benefit. With this one, we know the dates that people entered. If they entered after February 24th, that's qualification number one. Number two is they have to be Ukrainian. It says that on the I-94. Number three, it has to say the status that they entered in parole status. And it says that on the I-94. So that's all that the statute requires, that they have to be able to demonstrate. And so they don't have to make any changes on the document. So pretty much it's just making that little fix in E-Verify to recognize that I-94 as a valid document for E-Verify purposes. And hopefully that they did that for the E's and the L's. They know exactly what they need to do to fix this for this population. I would guess they will probably say that's a complicated thing to fix, but I think the reality is probably a one-day fix if they wanted it to. Just my opinion on that, without speaking with expertise on the programming side of E-Verify. All right, Jesse. We have some. I don't know if we want to talk about any of our other existing cases. I know people always want to know what's happening with the lottery, the DV cases, and Go. There is no news on that. We are in a waiting period and we are going to be in this waiting period probably for a couple more months.
Yeah.
But in Go and Gomez, basically, we had the arguments in September in front of the DC Circuit, and until we get a decision out of them, don't expect any meaningful news as far as what's going to be happening.
No, I mean, we've shared some emails with government counsel, at least the Gomez team, in terms of trying to get a sense on whether they've established perimeters, because they're supposed to keep up system. They're supposed to update their systems and have everything in place should there be a favorable outcome for the plaintiffs. Mm-hmm. And there was some rumors about that they had already closed, had set kind of perimeters in place or cut off people, and had come to some type of number of those that may be available. And we just wanted to make sure that if they disclosed it so we could better advise the class. But other than that, I mean, again, it could be the same question, but the appellate court is going to decide when it decides.
Got it. All right, so that's news on Go and Gomez. So there is no news. Is basically it. We're having some communications with them, but there's nothing that's actually anybody needs to act on at this point. Okay, let's talk about a couple of new cases that we are just getting going with. We have a new case on employment authorization document delays. This is a follow-up to last year's Kang case, which was a successful case for us. And this is a case that is for people who Kang was only for adjustment-based EAD applications. The new case, I believe, is broader than that. We're not. There's a couple of categories that are excluded for EADs, like asylum, but for the most part, most EAD categories are included in this suit. And that one we have we'll be onboarding for the next couple of weeks. But what happened in Kang, and the reason why people should be encouraged, is that it was a win and a loss. But the win part of it for us was we had 100 some odd plaintiffs in that case, and the government very quickly adjudicated the EAD cards for all of our plaintiffs, and that was a win for them. We were also trying to get class certification, and the government successfully argued that because they had adjudicated all of our plaintiffs, they were able to get a motion to dismiss, approving the judge didn't proceed with the class action. So we had given the warning that we're just going to come back and sue again. And if the government wants to keep doing this, where they will quickly approve our EADs, that's good for our plaintiffs. We're going to try again for class certification, but that is that's the strategy we're going to go with. So we're doing that case, and we're doing another case that's similar to that for the first time for advanced parole. So if you are in a situation where you are delayed, well, I will change the banner to say EAD and advanced parole. If you're in that situation where you are waiting on either one of those, these two cases are potentially of interest to you. So you can just go to IMMPactLitigation.com and you can see where we're onboarding for those cases. And hopefully we'll be able to get fast results for our clients. You never know in these cases how hard the government's going to fight back, but at least on the initial EAD case, we had some pretty quick results. So hopefully that will be repeated. Jesse, I don't know if you have anything to add on that.
No, but I mean, of course, the reason there's two cases and not one is because the agency decided in their infinite wisdom that they didn't need to issue cards at the same time anymore. And so a lot of people are getting cards that they think would allow them to travel, and they don't. And then they're not issuing them the I-131s, which is the advanced parole. And for a lot of people, that's more important than the work if they have other non-immigrant status. So it's a big deal. It's a huge deal, and we hope to correct it.
Yeah, and Jesse, you and I think when maybe on Twitter, we can start giving a little bit more information on both of those cases, as well as the wastage case, to kind of create some more awareness for people that are not seeing the videos. All right, the other case that we are working on, and I was hoping that we were going to have the link for you to announce before today, but I still keep getting test emails so I know they're still working on it in my office on the apps. But we are going to be filing for a delay case on I-601A waiver applications, and this is for those of you who are not familiar with the I-601A. It is a provisional waiver application that allows somebody who is subject to the 3 and 10 year bars to potentially get a waiver of that from within the United States. The way it used to work is up until the Obama administration, if you were subject to a 3 or 10 year bar because of a visa overstay, for example, or for some other reason, you had to leave the United States, apply for the visa, and then wait and then either wait for the waiver or just wait it out, the 3 or the 10 years, before you can come back. So obviously a lot of people who were eligible for green cards, that was so risky for them as far as potentially being separated from their families for so long that they just didn't bother applying. They stayed in the country illegally, even though they could potentially get a green card if they can get a waiver. The Obama administration changed things so that mostly spouses, I think there's one other category that can benefit from it, but where they can apply for that waiver from within the United States rather than having to wait till they leave the country to apply for the waiver. That's hugely beneficial, except what's happened is in the last couple of years, that wait period has gone from 4 months to almost 3 years, or in at least one of the service centers, and about 2 years and change in another. And that is causing a lot of hardships for people who otherwise are, should be eligible for green cards, probably have decent cases for these waivers. And then also they can't work legally while they have this. So for a lot of people, it's they're either working illegally, which is not a great thing for our government to be encouraging, or they are, they're not working and their family is really suffering on there. So that's these long wait times really have pretty tragic implications for a lot of families, and we're going to be suing on that issue. And we will start onboarding hopefully today. So if you're in that situation where you have those cases, if you're a lawyer and you have those cases, we welcome you to refer your clients, and we'll have more to say on that probably soon. But that's a pretty important case that we're going to be litigating. Jess, I don't know if you have anything to add.
No, it's just, I don't think it's just simply because of COVID that the times have screamed so much higher. It seems to be an intentional kind of decision to not process these waivers. And the other thing is, you cannot understate the harm, because these people are essentially trapped. They have no status, and that's scary to begin with. So they have to live in this perpetual state of fear, and they have to have an immediate family member who's sponsored them, who's there. They already have a visa petition approved. They need to have that before they can apply for the waiver. So there's really a lot that they actually have in their favor in terms of warranting a favorable exercise of discretion. It's just that every single benefit is ahead of them, and they cannot get anything until these waivers are adjudicated. So it's an important issue. It really is.
Yeah. And again, these are people who paid a fee and, they're not getting the service on there. So, all right. I don't think we have any other cases to talk about right now. We have a couple of questions. Phil Cook, familiar name. Hey, Phil. Phil is related to Chuck very closely on there, and he's an immigration lawyer in Utah, and he's asking about a humanitarian parole lawsuit. So that has been under discussion for a while. There is actually a mandamus suit right now for Afghan humanitarian parole that was filed in, Jesse, in your neighborhood.
Yeah.
And I actually emailed with Susan Cohen at Mintz about that this week, because I am doing a Hot Topics panel at the AILA Central Florida chapter conference this week. And I'm supposed to be talking about what's going on with Afghanistan. And Susan told me that case is, let's see if I can find her email real fast. But yeah, she says, so they had a hearing in August before Judge Burroughs, and they argued against the government's motion to dismiss, and they're waiting a decision on the case. She still thinks it's very likely that their judge is going to rule in their favor on the motion to dismiss, and they're hoping to get a decision before the end of the year, and that they're really hoping to push the government to have to produce the administrative record, and they're dragging their feet on that right now. So that's we're watching that case as well as considering our own strategy. We had an idea, Aaron and I, on a legal theory that was a little bit different than just the delays on there, and some of it may depend also on if they do get that administrative record, on what we actually see. But one of the things that has been a problem on Afghan humanitarian parole cases is they have been, first of all, they haven't adjudicated most of them, but the ones that they have adjudicated, that fraction, most of the denials are just stating that you don't qualify for the program, and they're not actually explaining why, and they're just telling people they can reapply. There actually is a regulation that says that you have to provide a specific reason for a denial when that happens, and we're not seeing that. We're not seeing that reflected in the decisions. Obviously, that doesn't necessarily get you a better decision than you might if the government's inclined to deny most of these. But we think that it's a lot harder for them to have to actually explain themselves in these cases than it is to just issue that. And to the extent that it makes it just as easy to approve these cases, right now, I think it's easier. It's as easy to deny the case as to approve the case. We want to change the equation a bit so that it's easier to approve the case than deny the case in terms of resources that are going in on this. And that will hopefully cause the government to rethink its current policy, which is that it's a big ripoff where they can basically take all these fees, deny most of these cases, and they don't have to explain themselves. That shouldn't be the case. And we want them to, at least if they are, for a lot of these people, the $500 fee that they had to pay was an enormous amount of work as far as finding people to crowdfund these people. Most of these people didn't have that money on their own, and they had to find family members. It was a big hardship for them. The government should have to actually explain themselves if they think that they can legitimately deny these cases. So anyway, we're still looking at that. We were hoping to see what was going to happen on this other case in Boston first, and see how that goes as far as developing our own strategy and trying to do something that would be adding to what was happening in that case rather than just basically kind of treading the same ground. So look for news on that hopefully soon. But as Susan said, hopefully by the end of the year, we'll have a lot more information on that. Okay, we have a couple of questions. One is from Rahul. He applied for an extension with an H4 via premium processing. The H1 got approved. H4 is pending. Can you travel outside the country? Apply. There's a lot of questions packed in here. Apply to EH separately the first time. Still processing. Will there be a biometric? So first of all, they shouldn't be, Jesse, doing biometrics, repeating them.
Nope.
As far as the ability to travel on there, I mean, that's all comes down to essentially whether you have the, you have to have a valid stamp in order to travel on there. It's kind of a separate issue from the EAD. So, if your H4 is already approved and the stamp is expired, you can travel, but you should know that you're going to have to get a visa appointment. Rahul, you didn't say what nationality you were. I assume you're Indian from the from your name. But assuming you are, there was some good news out of India in the last couple of days regarding a freeing up, I think, of about 100,000 appointments for non-immigrant visas. And so it's hopefully a little bit easier for Indians to get those appointments scheduled and actually for those appointments to be kept.
Yeah. So I will say though, there's a huge issue, and it's worldwide, but it's particular to the embassy and consulates in India as well. So a lot of people are finding out is they'll go to the Dropbox and then they'll get called in for an interview, and then lo and behold, they'll get put in admin processing, and get issued a supplemental questions or 5535, and what turned into a 3-week turnaround is now a 8-month turnaround. And again, I litigate cases, so for me, when I see something like that, and every day you're outside the country is one less day your visa is valid, I would just file. I mean, I know a lot of firms out there say, oh, you got to wait 6 months. You don't have to wait 6 months. That's ridiculous, especially when there's family separation. I think that is I got to be honest, I'll go on record. I don't think the use of the 5535 is legal. I do not see how they can start putting additional eligibility, which is what I see when I see a 5535. Like, give me your 15 years of travel history. Why?
Yeah. I mean, I think there's a lot of evidence right now, anecdotal evidence that's being abused. But just as a general rule, for the last, it was since the Trump administration, and then COVID, and even more so. A lot of immigration lawyers have just given a blanket caution to clients about travel, where they are depending on a visa stamp to be able to get back into the country. It is definitely hit or miss. I can tell you that there are discussions that are happening with the State Department about having stateside visa revalidation, which would solve a lot of these issues. The State Department held an open forum recently with immigration lawyers said that they're working on that, but made it clear that they were prioritizing people outside the country first before they develop this new process. Although my feeling on it is, it's like, if you have this domestic processing, you would have less people outside the country anyway that needed it. So the backlogs outside the country would come down just by having this available, rather than just building and building and building, which is what's been happening. By the way, this visa revalidation, this is like basically the old becoming new again. For the first 10 years of my practice, it was available. That was a thing up until 9/11. And then they basically, I don't think any of the 9/11 hijackers even used visa revalidation, but they decided that they had to look at the program, and that they were going to bring it back after they did the security review. And of course they never did. That's not that. And that was the same as well for the transit without visa program and some other ones where, the government said, we're just going to study, we're just going to make sure that everything's okay on this. And then as soon as the program went away, they turned their attention elsewhere, and nobody ever, focused on bringing it back. It seems like that happened with visa revalidation, and that's hopefully finally, after 20 years, going to come back, because it really was an essential part of how consulates, it took a huge burden off of consulates to have that program available. And obviously we're seeing the consequences of it today without having it. Okay. So this is the perennial predictions on the appeal. We're optimistic people by nature, but I think that it's foolish to give those kind of predictions, because if we say we predict victory and it fails, everybody thinks we were idiots, and if we predict failure and it wins, we also look like idiots. So
well, the other thing too is, if you're a Gomez plaintiff, we need to win, and then you need to win. You need 2 wins. You just don't need 1, right? You need to win, and then you need to be one of the ones selected, because there's only 9,095 available for 2020.
Go. Acker versus the first case that we had, I think only had 12 plaintiffs left in that one, in there out of the original 100, but Go still has a significant number, so that applies to them as well. It's that we don't know yet, if we're successful, how those visas are going to be administered. And we don't know what the number is going to be. So there's like a bunch of issues. It's like winning. Does winning mean, we get exactly what Judge Mehta allocated, or do we get a higher number than that? So we don't know that. We don't know what the number is going to be, or if it's either going to be 0, Judge Mehta's number, or some other number, depending on how the court rules. So that all needs to be determined. Okay, let's see. We've got from CJ Johnson. Yep. So this is interesting. So she's noting on there that they only need about 1.5 hours per case. I guess that they estimate that, Jesse, when they do the fee rules on how much time it takes. So
yeah,
they have it's like the EADs. They take 8 months for a process that they estimate takes 12 minutes on there. So it's just strictly it's not that they've been that they can't work these cases quickly. It's that they haven't figured out a system to even manage them. Okay, and the last question is from our friend Simon, on asking if we wanted to challenge on that issue. So Jesse, I don't know.
Yeah, I don't know if it's. I think the difficulty in Britt knows this, or Simon knows this from the DV world. What is the best vehicle to do it? In individual cases that I've been filing for clients, they haven't really pushed back, knock on wood, and the client just wants the visa. So I would love, as a exercise, to have them tell me why they're using the travel ban waiver form to ask questions to a B1, B2 applicant. But I haven't got them to do it yet. So, but I don't know if it's part of a larger. I'd love to make me, and I'll stir it up with anyone. It's just that the client interest is just give me the visa, and what I want is not always, I have to listen to the client. So
all right. Yeah, true case get minute at. Okay, so that will end it for today. I think next week we're back at full staff, and hopefully I'm going to actually be in Miami next week at the International Bar Association's annual meeting. I'm the vice chair of the immigration section there, and I'm doing a panel that I know that some of the people here will appreciate it. Artificial intelligence as the decision maker in immigration proceedings. And immigration enforcement. And this is a global panel. It's a panel with lawyers from other countries talking about how the government is using AI and machine learning and big data to essentially do a lot of do things that are bad and maybe some things that are good in that space. But that's a subject I'm cramming on for the next several days to try and sound like I know what I'm doing on there. But that's where I will be next week. So I may or may not be here. Jesse hopefully will be. Chuck should be back. Aaron as well. And we will see all of you at that time. So have a good week, everybody. Thank you, Jesse.
Bye-bye.